thank you, Kamala, for the opportunity to be a part of this discussion. It's a very interesting one. And I have to say that I continue to marvel of the work that the Institute is doing for governance. You know, it brings such pleasure to my heart. So, you know, the topic today, should the role of the General Counsel and Corporate Secretary be separated? And my view is absolutely yes. You know, maybe at the end of the session, I might say, well, it depends. But as of now, absolutely yes, right? And reason being, you know, in my experience as a company secretary, I was never general counsel, but I've always been company secretary. And where I've seen the roles combined, general counsel and company secretary, in my experience, as we mentioned before, general counsel typically reports to the CEO, and company secretary would be accountable to the board through the chairman. But one thing we have to recognize in daily corporate life is that the CEO and the chairman do not always see eye to eye, right? You would like to think that it's all really a nice bed of roses in the boardroom all the time. But really and truly, there are many times where they don't see eye to eye on certain issues, and they are both there could be circumstances where they're both very strong individuals. So when you have a general counsel / company secretary in one person, as general counsel, you're reporting to the CEO. And as much as you might think that, no, I don't just tell the CEO exactly what he wants to hear. I've seen it happen. So the opportunity for that to happen could happen, because, you know, this is a person that might be responsible for your salary. This might be the person that might be responsible for your performance and whatnot, adjudicating on your performance. So there's that human element to the person. There's that human element that could potentially want to, here's what, I'm not advising anything that is illegal, but I would advise on the law pursuant to what you might want to accomplish, which sometimes may not be for the longevity of the organization. And when you sit as the company secretary in the boardroom, your focus and your interest is not necessarily on what is legal, which leads into my second point, that the roles are a bit different. As company secretary, we are focused on what the board should be doing, having regard to all of the information that is before it. And it may be, yes, what is legal, but a lot of other elements as well. So if as general counsel, there's the opportunity to advise the CEO on what is legal, for him to pursue a particular path, a particular agenda. When you sit in the company as a company secretary, you might realize that that is not it. It may not be what the organization needs for its long-term success. So, you know, there's the purpose of the two roles are different, and there's the opportunity for humanness to step in, right? So in one breath, you would advise the CEO on a particular course of action, and now having be in the seat of the boardroom advising the company secretary, you may realize that that is not the best course of action when you have regard to all the information that is before the board. So it presents a conflict there. And it could compromise the independence of the company secretary, because you may just want to back up what you have told the CEO. So, you know, how independent, unbiased can you be as the company secretary, which you must be? You know, we just heard Dr. Prasad, and I think the question from Sawe spoke to it, the independence of the company secretary. So that is to me the major reason why I would have the roles separated, just to avoid the opportunity for that conflict.
Thank you very much, Ceronne. I will ask Karen, given that she has the LLB, I would ask her if she would want to respond to Ceronne, or to basically give us the other side, if she has another opinion towards Ceronne, before we ask FTS Diana if she would want to say something.
Sure. Thanks, Mohini. Well, fortunately or unfortunately, Mohini, I share your view, and it's really not a black and white. It's not a black and white thing. It really depends on a multitude of different areas that determine what the individual company requires, right? I mean, I do accept that there's value to separating the roles. I absolutely acknowledge that, you know, there is a potential conflict between the two, and you really do, in both positions, quite frankly, you really do need to have a good strength of character, understand your role, recognize your independence, and in many instances, you really have to be a diplomat, because in a corporate world, you are always navigating different personalities, different agendas, different objectives, to be able to, for the overall company or group of companies to achieve, you know, bottom line results, but also, you know, be, as most companies are aspiring to be, top of number one, right? Part of my role and part of why this conversation is near and dear to my heart is that I have grown up, per se, in the last 20 years in a very dynamic financial services group of companies, where I have seen and experienced in reality both sides of the equation. So my perspective really is the answer. So whether you want to split the role, is that it depends. It depends on the size of the companies, the complexity of the companies, the industry of the companies in question, the geographies that you're operating in, how many subsidiaries you're managing. Those are all major parts of what is the best for the individual company. And then also, to a lesser extent, it also depends on the experience and skills and interests of the individual or individuals in the role, right? Because as you've quite pointed out, the general counsel strengths and interests and objectives are slightly different to the corporate secretaries. And in my experience, people tend to have a preference, right? They tend to have a stronger area that they focus on. And by extension, what that means is that the side that they're less interested in takes a little bit more of a backseat, unless you're able to put a system, a structure in place that then picks up the slack, right? So for a smaller company, I would say for a smaller company, a newer company, one that's not in a regulated industry, I certainly see value to a joined role, because I think that you get the best of both worlds for the individual. And by having the best of both worlds, that means is that they can provide more value to the organization, right? Some of these smaller companies, you just don't have the budget for two roles. Sometimes you don't have enough of a workload on a corporate secretarial side, if it's one company, for instance, to really take up all of the time of an individual. And really and truly, by having that access to the CEO in your general counsel role, who, in my experience, when it works well, that general counsel is the real, you know, right hand of the CEO in terms of guiding and directing and supporting and advising. And then you have the fabulous role on the corporate secretarial side, where you also have access to the chairman, and also have access to the board's perspective on concepts, on strategy. And between that, you can marry the two and really assimilate all of the information that is coming to the company to provide the best service to both parties in the company at large, right? So certainly for a smaller company, I think a joint role is possibly preferable. I mean, there is the whole outsourcing conversation, which is still relevant. But for a bigger organization, a more mature organization, one that is highly regulated and you're managing lots more subsidiaries and geographies, then my position is a bit different. And that is that the roles and the workload and the expectations for that type of industry, it's just impossible for one person to fulfill both roles properly, right? And what that means is that what you will see, whether it's in title or in reality, is that there is a functional split within those industries, where you have support teams behind that joined role, if it is joined, supporting them on the legal services and advisory side. And then you will have the strong corporate secretarial and governance side supporting that role. So really the corporate secretary and general counsel of a larger company or group of companies, if it is a joined role, it means they are really acting as coordinator of the two areas to make sure the communication, because communication is key. When you have a separate role, you have to have your general counsel and your corporate secretary as a tag team together, sharing of information and knowledge, because it's only with understanding both sides of the equation can you provide the most appropriate service, right? So at the end of the day, what we find in life is that, you know, the question you ask is the answer you get. And that is informed by the information and the knowledge base that you have to give your answer. So in a split role, that aspect of communication between those two parties become critical. If you keep it as a joint role, recognize that you really are functionally separating the functions in any event. And with the increase in legislation and regulations and the risks for a bigger organization are just too high to not be servicing both of those functions effectively. So sadly, I am kind of, you know, it is a depend question, but my preference would be, or my caveat would be, in a smaller organization, I would probably say a joint role would be preferred. And in a larger, more regulated, more complex organization, then a split role is the better approach from a structural point of view.
Well, there we have it, the second view. Ceronne gave one view, and then we now have Karen giving us another. As I said earlier, the answer is to many questions, it depends. And I believe Karen is telling us exactly that. It depends. If it is a larger organization or if it is a smaller company or something like that. Now, I would want to ask FCS Diana if she can tell us her views on the topic. And just to let you guys know, we are prepared to answer questions. Let us challenge Ceronne. Let us challenge Karen to defend what it is we are saying here. For me, like I said, I am here to say that in my role as corporate secretary, I've been corporate secretary for Guyana National Shipping for many years now. And I would have recognized in the early stages in that role that yes, it was not needed for me to be having a general counsel alongside me to be, you know, my role was basically a 2-in-1. I didn't have a problem with that. However, as the organization grew, in 2016, when that change happened, it is because I advocated for that change. It was because the job had become so much. As readings, I'm pretty sure many of us are reading with regards to company secretary and what it is and whether we should be joining the role or not. As it is said, if you are doing this dual role in organizations that are medium to large size, then you have to be a superwoman or a superman, right? And I certainly am not. And hence, I would have advocated for that slight change in the organization sometime between 2015 and it happened in 2016. Thankfully, it is not a case where we do have a general counsel on board. They haven't decided on that as yet, because always in every organization, cost is a factor. But we did have or make a change to incorporate a junior legal person on board that can give legal advice outside of me taking on both roles. So Karen, yes, your point is very valid. Ceronne, I know we have differing views on that. And like you said, maybe by the end of this discussion, we can continue to either stay that way or lean the other side. Diana, what do you have to say?
Thank you very much, Mohini and my co-panelists. So I really like where Karen has brought the discussion. and maybe to share my experience. Now, greetings, by the way, from Africa. It is now 3:30 p.m. in the afternoon. And so nice to hear from all of you at the Caribbean, and very delighted to be here. So in Kenya, especially in the public sector, from my experience, we have a code that governs operations of boards in public sector, which is known as the Mwongozo Code. This code recognizes that there should be a corporation secretary, who is the person who will be responsible for all governance, advisory, and support for the boards of public entities. And in recognizing that position, the head of public service in our country actually issued a circular to state-owned enterprises to require that this position should be made up of a corporation secretary / head of legal. This position has been adopted by all state-owned entities across the board. And at the moment, we have that role reporting to the CEO functionally, and reporting to the board functionally and to the CEO administratively. So that is an aspect that has already been entrenched in the public sector. If you look at the private sector, that position is quiet because we have also a code for issuers of securities who are listed in our securities markets. And that code requires there should be a qualified corporate secretary who would assist the board on all issues to do with governance. That position should be held by a person who is qualified. It doesn't go ahead to say what other roles that person should hold. That gives me the reason to agree with Karen that really it depends, because if the guiding instruments already indicate how that position should be structured, I think that gives guidance on what the best practice would be. The size of the company already has indicated, the scale of the work that is being done, and the regulatory aspects of the operations of that business will also determine the structure. So because this has been extensively covered, I would like to now turn to the pros and cons of combining both. And maybe I should start with the positive, which is the fact that these roles are held by professionals who are very highly trained and highly qualified. And that aspect of advisory, both professions give advice. So the GC would give legal advice. The CS would give governance advice. So the advantage of having these two roles under one office or one person is that there will be seamless consultations, seamless procedures, and efficient responses on issues to do with advisory. And governance and compliance cannot really be separated. These are twins, and it makes it more efficient and more clear when the position is handled by one person. We also have issues of compliance. Both the GC and the CS are responsible for compliance. The GC on one hand to ensure compliance with all laws and procedures for purposes of legal compliance. Like in Kenya, for example, we are required to do legal audits where you're supposed to audit the legal compliance of your organization once every 2 years. When you come to the side of the CS, you're supposed to conduct a governance audit, actually annually on the other hand. So just to make sure that the organization is operating within the setup governance standards, that all the requirements that the board is supposed to meet have been met. And so this is an issue of ensuring compliance. And it only makes sense and it makes it easier, more effective if these are done by the same person, because then the end is the same. The end game is that to ensure the company is complying in its operations, the board is complying in its operations. And the other issue is the issue of cost. These are professions handled by very highly qualified persons. Having separate departments or people handling those two functions will be more costly to the organization. But where you have a fused role, you find that the company is able to save on costs and can as well outsource. So this will enable the organization to get external advice, which can be more robust because it is outward looking. We have the professionals who can be outsourced from outside the organization can give advice that is more objective and more outward looking to the benefit of the company. In instances where you may have to have an individual handling the dual roles, then it means, having distinct roles, then it means that person would more often than not be required to specialize, and more often because of the cost implications already of two people handling the two positions, then outsourcing may be a limited option. Moving on to the disadvantages, the first one that glares at me is the issue of advocate-client confidentiality or privilege, in other words. So when you hold this dual role, at some point you may be giving your advice to the board as the CS, either on aspects of governance, on legal aspects. But where do you draw the line to say that this is advocate-client confidential, is protected by advocate-client confidentiality? And where do you now retreat and say that now I was giving my advice as a corporation secretary? So when issues arise, we saw in the case of Ceronne, the Australian case, where the GC/CS was found liable for not giving the right advice to the board. And his defense actually was no, he was acting in his capacity as a CS, but not as a GC. But we could see that he was found liable, where the court said that those two positions cannot be distincted or separated for purposes of determining liability. The other disadvantage, the second one, would be the workload. Both roles of legal and governance are very highly technical, and they are very heavy in terms of the responsibilities, because the organization depends on the holder of this position to make sure they are always doing the right thing at the right time and always. So the weight on the shoulders of the position holder is very high, and the workload can also be quite a bit. So unless the organization is able to give adequate resources to be able to support the CS/GC, this can be an issue for the person holding both positions. And maybe that is where I should stop so that we get feedback from our delegates and respond to them. Thank you.
Thank you so much, Diana. In 2019, KPMG would have done some interviews, and they would have narrowed down their research and discussions to basically saying that the roles are too big for one person. Two aspects, basically. One, the roles are too big for one person, and two, that it can represent irreconcilable conflicts, or at least lead to confusion as to which hat is being worn when. And definitely you brought that out in the case, as you mentioned. I would want to say that we are open to discussions and to questions, challenges, let us hear. If not, I would want to ask any one of my panelists if they want to add to what has been discussed so far, if we don't have any questions from anybody in the room.
Yes, Mohini. I definitely hear the argument about size and complexity. Yeah, and I run, for example, I run a small organization with my husband. It's a family business, but because of my passion on the separation of the roles, we outsource our legal advice. Yeah, so I know Karen spoke to that. So that even within a small organization, it's more cost effective for us to outsource legal advice and to have an in-house legal counsel / company secretary. I mean, we benefit from my expertise as company secretary, so we don't have to go out and hire a company secretary, you know, so it works well for us. But sometimes you might find it even more cost effective to outsource your legal advice. And another point I want to raise is a company site. Remember Kamala, we did a session some time ago about, I'm a company secretary, not an attorney. And what I've found is company secretaries, where it's combined, they tend to look for attorneys to fill the role. Yes, and what I'm saying is I am not an attorney at law, but I'm a company secretary and I'm trained in law, business, governance, and so forth. So one of my missions as somebody as a governance professional is to advocate that the company secretary doesn't necessarily have to be an attorney. And sometimes when you hire an attorney because you're looking for the general counsel / company secretary, the attorney may not always have governance qualifications. So the company secretary is a profession in itself, right? With its own unique skills and qualifications and you know, personality of the individual that may differ from what you require from an attorney. Yeah, so, and even in the large organizations, for the role to be combined, the workload, you know, Diana spoke about the workload. And Mohini, the same experience you went through in 2016, I went through in the organization I was in 2011, where there was a general counsel / company secretary, there was no legal department, and they decided to create the legal department, and he was in charge of the legal department and secretariat all at the same time, and it was crazy. I supported him at that point in time, yeah, and just the work alone was under him, and you know, he had my support as I worked directly with him, but even for the two of us, it was crazy. So we actually had to hire a manager of the legal department who would deal with the legal department and the staff and all its requirements. So he still had the position of general counsel / company secretary, but he himself could not handle it all. So maybe there's an argument for, in terms of workload, for larger organizations where the role is combined, to have more support for the two different departments, the legal department and the secretariat, do two very different things. Yeah, so that's what I wanted to add to the discussion for now.
Well, Ceronne, I think I agree with you. I think that definitely it really does. There are different perspectives in terms of the skills, and more often than not, the roles I think traditionally have been joined, right? Which is why you tend to find a lot more attorneys in the corporate secretarial roles. So it is interesting, and it is something that's important to know, that you really don't have to have an attorney to be a corporate secretary. What is important, I think, for a corporate secretary is to have that blend, right? To have the legal knowledge and expertise and understanding, in particular on corporate and companies law, securities law in particular, and be able to blend that with, you know, the business side of things, the acumen, the understanding of governance and the obligations of the organization to steer the company right. So I agree on that point. Two things just flagged for me in Diana's conversation, and also in yours, Ceronne. One was, I suppose one of the things that flagged for me is culture. I think culture is very important in making that determination as to where a company is going to go. If traditionally, sadly, because it has evolved into a profession of its own, but the reality is there's a perception of the corporate secretarial role to be an administrative role, and not that governance professional that we all know is the case and are advocating for. So if you have a CEO or a chairman who is of the view that the corporate secretarial role is not a valuable role, then they're not going to get support in splitting the role, right? And that's just the way that it is. So Mohini, in your advocation, you obviously had, a good position and a good support from the people that make those kinds of decisions. But it is important for us culturally or for the directors, the CEOs, the chairman of organizations to understand what the corporate secretarial role has become and the value that it adds, to recognize that it's not just somebody take minutes, somebody sits on the side and take minutes.
Absolutely.
Right? But then that leads quite nicely into Diana's point, which is a very important point, and we do need to navigate as well, because in that corporate secretarial role, you are the one sitting in the boardroom more often than not, and you are the one that the board may ask for advice on certain things that you will give, right? And you are the subject matter expert, so you can give that, to give that advice, pretty solid advice, I would dare say. But at the end of the day, you do not have that level of privilege that attorney will have in giving advice to the company. So there is the potential to, I hate to say it, but there's the potential to expose the company by giving that advice and being the one to give that advice, because you're not the lawyer. In some instances, well, should I say, where you have a joint role, you have both hats sitting in the room, right? You have the corporate secretary and the general counsel sitting in the room with the board. And so when you're giving that legal advice, separate to that argument that was, obviously rejected, Diana, but they can wear that general counsel hat and give the advice from an attorney's perspective in the boardroom, right? But it is something that has to be navigated very carefully, because you can certainly expose the company to liability.
Absolutely correct, Karen. We know that basically the role of the company secretary is enshrined in law. The role of the general counsel, however, is not. That an organization must have a general counsel. And I believe that is where the discussion has to change. We very well know, once we have an organization, we must have a company secretary. There must be records of what we are discussing at the level of the board and everything. And therefore, taking part of the company secretary's role is what is mainly the focus, right? The general counsel and the legal advice that is needed in most organizations when we're sitting in boardrooms. I totally agree with the presentation where we said that, the CEO may be the person adjudicating on our performance as the general counsel, and one may not want to challenge a discussion if there is a heated discussion in the boardroom. So we have to understand that at some point, the company secretary was seen as not adding value to the organization really at some point, but that is totally changing now. The dynamics are changing. And I believe the focus now is not the question of just taking minutes, but more of what it is, the corporate governance, given that governance is becoming such a big thing in organizations now, the issue of giving proper guidance, not legal guidance, but governance guidance, and the role of a company secretary is what we are now seeing coming up. And then we do have the aspect of legal advice, which is also needed at some point, not necessarily all the time in a boardroom. And maybe that is where the discussion is shifting as to whether the roles should be separated. And that is what we are challenged with. But sometimes in mostly in larger organizations. Medium-sized organizations can get away from it. Ceronne, you are doing maybe the best thing, even though your organization is small, you still have it separate. But it is still a discussion. And again, like we started this discussion by saying, most time the answer, it depends. So
the question that I have for you is governance more than compliance?
Who would want to answer that? For me, I would want to say they go equally hand in hand, but governance for me stands out. Compliance, yes, but governance, if you are treading the right path with governance, then compliance become a non-issue because you know what you are doing basically, and you know the right thing. You're doing what has to be done. So compliance become the bottom layer basically because it is there. It is what we are doing. But I would want to say, yes, they go hand in hand, but I would still put governance as the top layer because we have to know what we are doing.
Yes, yes.
I would agree.
I agree with that. Compliance, I see the role of the company secretary. Compliance is one part of the role, but I noticed that with compliance, boards, they tend to take a checkbox approach. Okay, we've done this, because you're going through the list of everything we have to file and all the regulations and whatnot. But governance as a whole, it involves, you know, the purpose of the organization, the board to do the right thing. So yes, as Mohini says, you know, if we have governance in check, compliance is a natural byproduct of it, I think.
I agree with that.
I wanted to add my voice to that as well, because for me, compliance is actually an end after you've done all the proper governance, because governance is more so keenly about stakeholder engagement. Because in doing a good corporate governance, you are making sure that you're meeting all your stakeholder needs, be that of your regulator, shareholders, employees, the directors, and in putting all those systems, checks and balances in place, the end product is compliance. So for me, I think I look at governance as wider because compliance is just the product that will come after you have exercised all the good governance practices. Thank you.
Absolutely, the stakeholder interests, I found, you know, within the last 10 years or so, we are seeing, probably longer than that, more of a need to take stakeholder interests into account. You know, so whereas before it would, you know, with bottom line, we have to serve for the benefit of the members. And yes, that is still so, we're still doing that. But the stakeholder interest is pivotal now, you know. You have the millennial age group, right? They, with their social issues and whatnot, if you make a mistake or have some sort of conflict in that regard with regards to social governance and environmental governance, it could impact your bottom line as well. So stakeholder interest. And that's another reason why, you know, for the roles to be split. When we're in the boardroom, when I was company secretary, we had the manager of legal would also be in the boardroom for the legal advice and whatnot. But when the discussions of those stakeholder interests come into play, right, because you want to show as well that the board has taken into account stakeholder interests, you know, that may not be where the head of legal might be thinking. Yeah, he's just thinking on the law. So stakeholder interest is a huge part of governance, huge part of governance.
Definitely, Ceronne. I believe Zara has a question for us or a comment.
Thank you so much, Mohini. It's not really on the current discussion, but something that Diana said was quite interesting for me in the sense that there was a regulatory requirement for the public sector to actually have the role as one role, but not for the private sector. And I was just wondering what factors would have contributed to that kind of decision. What would be driving the public sector to want that to be a dual role, as opposed to regulating it for the private sector? Might be a bit of an unfair question, Diana. I hope I'm not being unfair to you.
All right, thank you so much. So for companies, state-owned organizations, The requirement is the corporate secretary should also be the head of legal. And from my perspective, it could be government's strategy to manage its wage bill, because then you can see in this sense, most company secretaries would be lawyers as well by profession. So for the government, it is a strategy, I would say, but not with full confidence, to manage the wage bill, because then instead of having these two positions, getting two people to handle these positions, then they are able to get the value for the two roles in one person. Number two, this position is looked at as a position of giving assurance to the stakeholders that all the compliance is in place and the organization is running in accordance with the governance practices. And for that purpose, there was need to make sure that this person is given the right position in the structure of the organization. And so you cannot have two directors reporting to the CEO, one on legal issues, another on governance issues. So therefore, this role has been put there. So it reports to the CEO administratively, functionally to the board. So it is given the stature that it deserves in terms of access to the highest levels of decision making in the organization. So that would be my attempted take on that, Zara. But for private companies, you will agree that these are, they have their own shareholders, and the shareholders have a right to make a determination on how they want to run. So what the regulations or the code guides is that there must be a qualified corporate secretary. So then it is upon the company, depending on its size, the complexity, its budgets, to decide how this position should be structured. Thank you, Zara.
Thank you, Diana, for answering. Zara, I hope you would have gotten some insight here. But I believe we have Faye has a question for us also. Faye had her hand up.
Oh, Kamala, I think Kamala had her hand up first. Kamala, you want to go ahead?
No, that's fine, Faye. I love how the discussion is going. So I'm going to step back and allow you guys who are working as corporate secretaries.
Yeah, I just wanted to throw in a few points here, you know, and disclaimer, I am a long-serving joint general counsel and corporate secretary. And I think as Karen pointed out, the larger the organization gets, at some point you end up being a sort of titular head, because you actually create departments under you that carry out those functions. And I actually found Dr. Prashad's feature presentation very interesting, because he reflected a lot of what my experience is on the general counsel part, in the sense that, you know, you do have a very independent role as general counsel. And I think sometimes people overlook that, and they kind of say, oh, well, the CEO is your boss, so you will do whatever the CEO says. I mean, equally concerning to a board should be the fact that the CFO reports to the CEO. So boards of directors have to be very conscious of these kinds of situations and the things that can compromise independence. And I think both roles, the CFO and the general counsel, by profession, have to exhibit a certain amount of independence. And I would always say that in my role, I thought I brought a lot of value to the organization as general counsel because of my independence. I had many directors and chairpersons call on me outside of boardrooms and say to me, you know, Faye, I know if I ask you this question, I'm going to get the right answer. You know, I'm going to get the truth. I'm not going to get an answer I'm looking for. And I think it's incumbent on you as a lawyer to build up that sense of independence, and that you will give unbiased direction and advice to whoever your client is. I just wanted to make a couple other points. We spoke a little bit about this whole question of the stakeholder, taking stakeholders into account, and that sometimes maybe the legal advisor will just look at the company position. But more and more, the legal requirement is for the company directors to look at the stakeholder position. And therefore, that's what the legal counsel has to advise on and take into consideration as well. And the legal counsel, I think, as Dr. Prasad was bringing out in his presentation, because of your involvement in the business, you don't bring that adversarial win-lose attitude to your advice, but you bring more of a win-win. You know, we are in this together. We need to have a positive outcome and that sort of thing. So I come down on the side of it depends, because I think that governance at the end of the day is a kind of it depends answer to, because we have so many different types of organizations with different needs. But I do think that sometimes the independence of the general counsel is overlooked. And I always go back to this article I read some time ago about Elon Musk, Tesla going through about 3 or 4 general counsel in quick succession, and shareholders actually launching an action to say, you know, that the board was not carrying out their duty because they weren't appointing strong enough general counsel who could stand up to Mr. Musk, which is, you know, an interesting perspective. And I think finally, and I don't want to hog the limelight, but finally, I think we also need to think of the workload of the board and the chairman. If they have all these different independent functions reporting to them, how do they manage that? How do they really properly evaluate a company secretary who is 24/7 in the job, but who they interact with maybe a dozen, maybe 24 times in a year? You know, so there's a lot, I think, that needs to go into that as well. So anyway, after those points, let me step back and let someone else proceed with their question.
Thank you so much, Faye. Thank you so much. Is there does any one of our panelists wants to say anything with regards to what Faye would have said just now? Or should we move on to any other questions? Kamala, I understand you had your hand up. So is there anything you would want to say?
Yes, actually, I have been really quite loving the discussion, but I want to say that there was a point Karen made that is important for us to consider. If you separate the roles, and then you have the corporate secretary and the general counsel not getting along.
What happens?
Because she spoke about the importance of how that role is in terms of communication and ensuring the efficiency in the governance of the organization. So there's that real danger. And of course, I really loved how Diana laid out the pros and cons. And for me, I felt the pros were a lot more. Because it really means, though, that the individual, it tells me that not everyone would probably fit the grade. But, you know, there are instances where you can have an individual properly managing that dual role.
Yes, and you see, the point that Faye just made about the independence of the general counsel as well, I definitely hear that. I hear that, and it may have been something that I don't think too often about, because me being a company secretary myself. But yes, I definitely see that the general counsel should be viewed as independent as well. But just too often in my experience, it has not been that way. And persons, I guess that where the role was combined, or even where it was separated, I've seen too many general counsels not really emphasizing their independence as they should. So all of this discussion is leading to as well the attributes and the skills and the characteristics of the people that are in those positions. Is so important, whether we combine the role or not, the attributes of the person, the character of the person is so, so important. To speak truth to power, as Faye would say, whether you're general counsel, whether you're corp sec, whether the role is combined, is so, so important. And I just don't think we see it often enough.
I completely agree with that. And Sarah, proceed. Proceed, Sarah.
Sorry, I was just wondering now where the roles are, just following up on Kamla's comment, where the roles are separate and the board gets opposing advice from the general counsel and the corporate secretary. What happens in that instance? Who has the higher authority if that is not, because in many cases, your corporate secretary does have a legal background, as in the case of Diana. She's very much a lawyer as well as a corporate secretary. So, where these roles are separate, what happens when there's a conflict in the advice that's being given to the board? Sorry, and I see Deborah has a hand up there too.
Good question, Zara. But before we answer that, let us ask Deborah what it is she wanted to say.
Hi, I just want to jump in and circle back to something Ceronne said. I am an attorney and I run the corporate secretarial services at a law firm. And the point that you were making that you do not necessarily need an attorney to be the corporate secretary. What I will say is if an attorney is the corporate secretary, I agree completely that it has to be a particular type of attorney, somebody who's very, very versed in compliance and corporate governance. Because if I were to go on vacation, for example, or sabbatical or whatever for a long time, I don't know that I would easily hand over to any one of my other partners here and say, well, I want you to run this portfolio, because the focus, if you're not, I also do litigation. So the focus is very different when you're in a pure lawyer in the sense of just a commercial lawyer to the focus that you place on governance and compliance. And I always bring a completely different perspective to my other attorneys here. And many times we have, arguments about, what's right. So I do agree that there's an element of non-lawyering that is very important to the role of corporate secretary. Now, having said that, I do think that there's that tension between general counsel and the corporate secretary, because I've had it when I am, some larger companies would ask us to do their corporate government side of things, the corporate secretarial. And there's a tension, and I can see it because I do litigation as well. So for example, when you are reporting on the ultimate beneficial owner of an organization and you're going up the whole line of ownership, sometimes there's a reason why a particular peg may be domiciled somewhere, but for tax reasons, they're saying that, the mind and matter is somewhere else of that company. But as the compliance officer, I have to report on, I need to know the line of ownership. I'm hearing everything you're telling me there. But if you do not give this information, the company is not complying. And there is that tension. So I come back to what everybody else is saying, it depends. It depends on if you are having somebody who's going to wear both hats, then they have to have a proper understanding of the commercial and the legal side of the corporate secretarial side. And in most times that person will be a lawyer. They cannot be so legalistic that they only understand the general counsel side of things. So I think it's a very unique type of person who can handle that role effectively if it's one person.
Absolutely, Deborah. I love that. I absolutely love that. It has to be somebody unique to be able to handle that that differentiation. And in answer to Zara's question, I think we have it right here, that it has to be that unique person. If there is a case where we have two separate persons, a GC and a CS, and there is different views. I totally agree. I believe Faye says that is when you need external counsel. So you don't take either of two advices. But so Katrina also mentioned in the chat that in the boardroom, the CS should not be giving legal advice. However, the dispute you are mentioning, Zara, may be emanating not from the legal advice that CS is giving, but maybe from compliance and governance issues. And that may be where we have to have, again, both persons may be strong individuals, right? But what may have to happen in that case is that the board may have to make a decision for themselves, taking both sides of the argument into consideration, and then make a decision without, going with GC or CS. So I would want to think that is basically what will have to happen in a case like that, if we are to have two separate personalities. I see Camille is raising her hand. What do you want to say, Camille?
Yes, because for some reason my chat is not working to raise my reaction. So I have been corporate secretary and general counsel for nearly my entire career. This whole concept of the conflict and all of that didn't really arise until more recent years. But I will tell you that where I am today is, can we truly serve two masters? When you are general counsel, you're part of senior management. You are part of that decision-making process that is saying, we need to get this done. We need this for the bottom line. And GC, find us a way. And you are really involved in finding that way. Minutes, what are those? So Secretary, you get those minutes done because, and not only that, if I am in court and there is this big litigation, what you talking to me about, some administrative issue for? Having played both roles, I can tell you, it is a struggle and you are required to be superwoman. And how many unique persons are there really in that world? And is it really fair? And is there anything wrong with that tension? Because if you are the lawyer fighting away, is there anything wrong with having a corporate secretary that says, Camille, I know you want to do this, but remember, we also have to do that. And being strong enough to remind you about those things. So I hear it depends, and having lived it and having now stepped back, and I'm looking forward to our next panel where we talk about what really are the liabilities. I really am thinking I'm coming down on the side that it needs to separate because it has so evolved, the role has so evolved. So I just wanted to throw that into the mix.
Well, I can tell you that the fight is continuous with regards to defending, with regards to the company secretary telling the GC that this is what we have to do, as much as we would have in GNSC where I am working at right now. As I said, I would have advocated for separate roles. There isn't a GC really, but there is a legal person. And the struggle is every day. Up to yesterday, I had the struggle of defending or having to tell the legal person, no, as much as you're telling me what you're telling me, I know what you're telling me is correct, but that is not what we should be doing in this circumstance. Governance issue takes the priority against your legal advice at this moment, right? So yes, Camille, it is definitely a struggle. And maybe that is where Simone's point initially of separating the role, whether small or large, is coming out as being very, very poignant. So it is indeed.
2 points I'd like to raise. Sorry, Mohini. 2 points I'd like to raise concerning what Camille just said in terms of the general counsel being a part of the management team. Yes, the company secretary is not, there's that argument, should the company secretary be a part of the management team? And while I remember I would attend the management meetings, but I had to, my purpose there was different. My purpose there was, you know what, I know this is what you all are planning and to propose. This is how the chairman might perceive it. This is how the board might view it. But I am not necessarily sitting there as a part of the management team as company secretary. So, you know, the roles are so different. Yeah, so that's one point. And, you know, the other point in terms of just the workload again, you know, and the tension, what I want to say is the manager, I mean, we worked with the head of legal who would provide her legal advice. And it is quite okay to disagree without tension. You know, so there's the need for the emotional intelligence. We don't have to agree to get along, you know. So there's that issue as well in terms of, you know, we may not be on the same page, but that's okay. You know, that's fine. You know, at the end of this session, I may still think it should be separated, but I love all of you regardless, you know. So there's that as well. You know, it's fine to not agree with each other without that tension. It's like, well, you know, I can't work with her and this, and it's not necessary.
Yeah, no, that's not right. And tension is healthy.
It is always healthy as long as it is understood that it is for the better good. And I think as professionals, that is where we have to understand the differentiation in the roles and what we represent. Whether we hold a cap of a CS or whether we hold a cap of a GC in the company. So is there, Karen or Diane, do you want to add anything to the discussion and the questions that we would have had so far?
And as they think of it, I just wanted to say that Faye has her hand up again.
Oh,
let us hear.
Thank you. No, I just wanted to say, you know, that as with so much in governance, the positions here are not always black and white and simple, and it depends is very much the answer. But I do think from my own experience that in your role as general counsel in a commercial organization, you understand the things. I think somebody mentioned it about, you know, Camille saying, you know, we have to get this done. We have to find a way. So that educates you in the commercial imperatives. But at the same time, you are the lawyer and you know you have to protect this company. So you need to give good advice. You can't just let them do what they want to do because that's what they want to do. So you have to manage this tension evolving in the organization as general counsel. And that experience helps you as company secretary to play the role and provide the guidance to the board. So you kind of wonder, can you really separate them completely and not allow each role to benefit from the exposure to the tension that each of them actually bring to development and evolution of that role? So I just wanted to make that point as well, because it was kind of coming across to me as we were continuing the discussion on you know, the company the general counsel sort of fighting for the client.
Definitely. Thank you so much, Faye. Any comments, Karen or Diana?
I mean, I think generally I agree, which comes back to my original point, small versus large, really. But I mean, I think ultimately, whether it's an individual's growth and experience or whether it's a corporate growth and experience, it's the same thing, right? There is value to be a part of a process where you have both, because both is what really frames frames your perspective to help you hone your skills and provide the advice. Whether that comes from one organization that grows from small to large, or whether that comes from one individual who starts in a small organization and sort of, works their way through different experiences to ultimately, when you get to a larger role, you can bring that perspective. And at that point, you have that strength of character and experience to see both pieces, to clearly understand your role and to provide that advice on the senior management side, but also in the boardroom. It is, to me, that it's a process. And when you get to whether you become an individual who has accumulated that experience, or whether you're a corporate entity that has gotten to that stage where it becomes required, then ultimately it's the same. You need to have it to be your best. I think you need both to be your best, personally.
I think also it very much comes down again to the independence of the corporate secretary. The role has expanded to the extent that the corporate secretary has to be able to engage with both internal and external stakeholders. So you have to have that point of view in mind, that you are acting in the best interest of the organization. You also need to understand the business, so you can't be separate from the management. You have to be able to understand how the business operates. And in that sense, you are going to be interacting with the various departments within the organization. And that is also what assists the corporate secretary when they have to influence the decision-making of the board, because they've got to bring all that information to them. So the whole issue, I think, is around that of being independent, being able to listen to the different viewpoints, and then bring your advice to the board in terms of what decisions they have to make. And yes, I agree with Ceronne that you've got to have that emotional intelligence and emotional resilience to be able to separate what decisions need to be made from any personal kind of tensions that there may be. So there's a lot on the shoulders of the corporate secretary, but as someone mentioned before, and I'm not being sexist, but they are superwomen.
True.
Definitely, and thank you, Zara. Diana, I believe Kana will be telling us shortly that we have just a few minutes left. So Diana, can I get any thoughts that you may have?
Yes, just to add on to what Zara has said, I think it's a very delicate balancing act, because you have to quickly put down one hat, put on the other, and in another sequence, put back the other, because management are executing the directions of the board. You are a part of the team that is executing. When the management reports back and the board is oversighting, you are sitting in that meeting and listening to the feedback that is coming from the board. So a lot of emotional intelligence, a lot of diplomacy needed, and the independence, and actually to be, I'm looking for a word, to be true to yourself, so that then you give the correct advice without actually feeling like I'm defending my colleagues in management, or I'm in management, I'm trying to please my bosses who are in the board. So I think we just have to be true to ourselves, independent, and reliable, diplomatic, and with a lot of emotional intelligence. But this should be a continuing conversation, even as the roles evolve. Thank you so much.
Thank you very much, Diana. I believe, as we are discussing, as Sharon says in the chat, she says she was always preface her advice by saying, I'm speaking now as General Counsel, or I'm speaking as the governance officer. A very smart move, Karen. Sorry, Sharon. A very, very smart move, Sharon. But even then, the two can probably not always mesh. The two advices don't always mesh. And that is where I believe that the whole discussion that we are having here right now stems. That is where it stems from, because the two don't always measure, two advices don't always measure, as was prefaced earlier in our discussions, and I believe it was Zara, no, Camille more so, who would have said that, it is not that you have one, the general counsel giving one advice, company secretary giving another. And that is where it, because of that, not always meshing, is why we're having this discussion, really and truly. And the pressure on more so the CS, because Diana, you're absolutely correct. We are, and I believe Pamela referenced it too. We, as much as we would want to say that we report to the chairman of the board, we are a part of the management team. One way or the, we are a part of the team. So is it that you're defending management, or is it that you're supporting management? Sometimes is the question, right? So basically, it is what we are talking about. I would want to think that at some stage in our discussion, the question that would arise, and I would want to hope that at some point there is a discussion as to whether both the roles that we are having here as General Counsel and Company Secretary will continue to grow in importance and will continue to diverge, irrespective of what we end this conversation with. We have to understand that it will continue to grow. The two roles are continue to grow in its own importance and to diverge. Whether we will at some point in time, we know that we see an advertisement for finance director who works along with CEOs and things like that. But will there be a time when, and maybe this is a question we should ask, will there be a time when we will have the director of general counsel or a legal director being employed in the company? Or will there come a time when we will have, and I think our keynote speaker referenced it, will there come a time when we will have a chief governance officer, or that title changing to chief governance officer? And will those two roles be separate? Will there be two different individuals coming around at some point in time in our, whether it is the current future or in our near future, that we will have those two roles being advertised, and we see that we get excited that we want to go apply for a legal director, or we want to go apply for the position of chief governance officer within a company, whether it is large or whether that company is small. I think that is where the whole discussion is going to probably change, and the dynamics of the discussion is going to change if we are to see those separations. So far, I can tell you in Guyana, I haven't seen those. I haven't seen any advertisement for a legal director. I have never seen an advertisement for a chief governance officer. What I'm seeing advertisement for, company secretary. And I know some more times than not, the requirement is that you must have an LLB, right? So I would want to think, as much as in our minds, we are thinking that the roles should be separate. I don't think companies would have understood it, or the management of companies would have understood it. And maybe this is the beginning of us having to make it, or wanting to make that change.
Yes.
And Pamela, I would want to say that in closing off the discussion on this whole topic, not necessarily closing it off, but to wrap it up, basically, that would what I would want to close with, as much as I would want to listen to others. I think I noticed that we're having some discussions in the chat. I don't know if you would want to help with that.
Yes, in fact, we have Ceronne who has joined us from Dubai. And initially, I wanted Ceronne to be part of this panel as well, but circumstances led to her not being able to confirm on time. But Ceronne, I would appreciate if you want to unmute and just share your thoughts briefly with us on the conversation that you're having now with Katrina in the chat as well.
Thank you for that. Yes, and apologies for that. I'm actually just out of the office, so I can't turn myself onto camera. It's a really interesting question, and I thought that I would put some comments in the chat, because we tended to treat it as a risk then. So it was then became a question of how do we protect the board and how do we protect the company secretary, who is also the legal counsel. So, and we had some interesting cases in Australia at around the same time, but these were quite obvious examples where the legal counsel provided poor, not just poor advice to the board, but actually they were negligent in the advice that they gave to the board. And he used that separation as a way to try and avoid responsibility, to explain what he was doing. And he said, look, when I gave this to the board, it was in my role as legal counsel. I was not company secretary. If I was company secretary, I would have not given it to the board. And of course, the judge did not take to that very kindly and turned around and said, look, you know, essentially, when you're company secretary in Australia, you are always company secretary. That comes before any other role that you do. So it was an interesting case. It went through multiple appeals, both for the company secretary and the directors themselves. So if anyone does look it up online, just be aware that there's a lot of commentary on it and quite a few versions. But you'll see, like at the end of the day, I would sometimes give conflicting advice to the board, and I would say, look, my job as a lawyer is to take you as far as possible and close to the line as possible without going over the line into illegality, you know, into illegal activities. However, as a company secretary, I have a more moral view, or I have a more holistic view, and my view tend to be more risk-based. So I will give you different advice. And if this was a big company, you would have two separate people in front of you. So, you know, think of me as two people, but it's difficult to argue against yourself. You do tend to say, you become quite pragmatic with your view because you can't simply debate with yourself. But at least it then tells the board, look, you have actually multiple perspectives to look at with this. And it's not my job as legal counsel and company secretary, it's not my job to make the decision as to what you think is more important or what you need to think about. So I try to put it back onto, you know, unfortunately back onto their heads. So I hope that's, you know, that adds a little bit to the conversation as well.
Yes, thank you very much, Karen.
Proceed, Kamla.
Yes, thank you, Mohini. So we are actually just a few minutes away from wrapping up this panel discussion. It really, I think, has been very, very engaging and certainly very enlightening for me as well. And clearly it is one that we need to continue to have, because both functions as general counsel and corporate secretary continuing to grow and expand, and both are becoming even more critical in the very fast changing environment in which businesses are finding themselves now. So definitely an area for us to continue to explore. So I want to thank Mohini as our moderator very much for really leading this discussion in such a dynamic way. It was really, truly enjoyable. Thank you, Diana. It's wonderful to have you from Africa here and to share your views with us. Right, thank you. Thank you very much, Ceronne. I mean, you know, since you have joined, and I'm happy to share Ceronne as a member of CCGI as well, you know, that she's bringing such value to our conversations and our growth here in discussing corporate governance in the region. And thank you, Karen. Karen really helped me out at the last minute because it has been a very interesting time getting all of our panel discussions in order. So Karen, I really, really appreciate your joining us and sharing your experience, you know, where you are with a very large conglomerate and having to deal with some of these rules as well. So thank you all very much.